the Alice Magistrates Court currently making a ruling on the discharge application that was filed by the legal defense of a team for a former University of Fort Hare employee accused of fraud, money laundering and corruption. Let's listen in.
Such crime would take longer to complete than crime of a lesser technical nature, close quote. The third and final factor is the systematic delay. Now, the court in Sanderson, more specifically at paragraph 35, held that systematic delays cannot always be accepted, but admitted that within the South African context, we are not yet there. The court further held that systematic delays are more excusable than delays caused by ordinary investigations. Court also held that when systematic delays are advanced as the reason for the delay, it would serve the accused and his legal representative well to bring evidence showing that the average systematic delay had been exceeding in the matter. And lastly, the court held that if an accused cannot do that, a court will find it difficult to determine how systematic delays are enough. Close quote. Now, the authorities I have just cited above, together with an article by Andrew Swartz, which was published in the Direbus in 2024, succinctly explain the approach that must be followed in terms of the 342A inquiry. Now, in this case, the state has considered, rightfully so in my view, that there are delays, even though they are not unreasonable. On the other hand, the legal representatives also appreciate that the matter is complex and that the docket is quite voluminous. It has been brought to the attention of this court, therefore, that accused persons are facing more or less about 1,200 counts or even more. Now, these are white-collar crimes in nature, wherein the juristic persons such as companies are also cited on the charge sheet. The court, therefore, must strike a balance between the complexity of the case and the rights of the accused persons in determining whether the delay in the matter is reasonable or not. Expeditious conclusion of criminal proceedings is central to a right to fair trial. I cannot overemphasize this aspect more than Justice Grichler did in the Sanderson matter, which I have referred to above. Now, this matter has been on the roll for at least a year, and it will most probably be tried in the High Court. Inasmuch as the courts should not be rubber-stamping postponements that are sought without good reasons, my view is that courts should also exercise judicial caution and not be quick to remove matters from the roll. My emphasis. In an unreported case of S versus Porritt and another, case number SS40 of 2006, GJ in brackets, the accused in this matter faced more than 3,000 charges of fraud, racketeering, contravention of the Income Tax Act 58 of 1962, the Companies Act 61 of 1973, and the Stock Exchanges Act number 1 of 1985. Though they were arrested in 2002 and 2003, respectively, their criminal trial commenced only in September 2016. My emphasis. Now, Mr. Botha, for accused number 1, argued that his client is in custody and his health has worsened. Almost all the legal representatives of the accused persons cited financial prejudice as one of the things that this court should take cognizance of. Accused number 1 is indeed in custody since he elected to abandon his bail application. But correctly so, he cannot be blamed for such delays. However, one must bear in mind that he has got another matter wherein he is in custody with no bail as it was refused. The state is seeking a remand for a period of 3 weeks to obtain the certificate according to Mr. Ndelwa. And according to him, an indictment cannot be prepared and served on the accused persons prior to the certificate being obtained. Mr. Ndelwa for the state argued that the matter is complex and that the docket is quite voluminous. He further argued that the matter had only been remanded 4 times for further investigations. He argued that before the certificate can be obtained from the Office of the National Director of Public Prosecutions, the matter must go through certain personnel within the Office of the National Prosecuting Authority. This court is of the view that there is a delay in the matter, but the question is whether such a delay can be considered as being unreasonable.
All right, those are live visuals from inside the Alice Magistrates Court in the Eastern Cape. And in fact, a judgment is being delivered on the wake of a request by one of the accused in the Fort Hare fraud matter to essentially get a discharge from this particular trial. And the judge there is still outlining some of the background related to how they got here, including, of course, how this particular accused lawyer mentioned that his client's health, has deteriorated whilst he's been kept in custody. It's a matter that's been in the courts now for about a year, maybe even slightly more, and it's to do, you might remember, with widespread fraud and money laundering that apparently has taken place at Fort Hare University. Reports suggesting that there are 2 fraudulent schemes that have now been found, draining that institution of about 2 million rands. And it's certainly the kind of problem, of course, Fort Hare doesn't need, given the long list of issues at that once very prestigious and highly regarded higher education institution.